Assalamualaikum. I will start the presentation with the introductions. Banking secrecy is described as a conditional arrangement between a bank and its client that all of the above operations remain secure, confidential and private. A country that provided funds to foreigners on a level that is immeasurable by the scope and funding of its domestic territory is known as the offshore financial center. Tax havens, usually countries or areas with little to no corporation tax, that make it easier for the foreigners to set up companies there. Banking secrecy is disclosed in the Section 133 subsection 1 of the Financial Services Act 2013. It specified that no individual who has access to any record or information relating to the affairs or accounts of any clients of a financial institutions, including a financial institution or a person who is or has been director, shall reveal to another person any document or information relating to the affairs or account of any client of the financial institutions. In Malaysia, the International Offshore Financial Centre was declared in Labuan in October 1990. It aims to supplement the activities of the domestic financial sector in Kuala Lumpur. The banking secrecy in Labuan Financial Offshore Centre is very strict, where the Malaysian federal government cannot access the information. Since Labuan Island is part of Malaysia's jurisdictions, Malaysia's legal structure is based on British common law, which means that it is ruled by the same rules. The Labuan Financial Services Authority is a legislative body formed on 15 February 1996 under the Labuan Financial Services Authority Act of 1996. Promoting and developing Labuan as an international hub for business and financial services is one of the purposes of Labuan Financial Services Act.
Okay, relevant laws. Okay, number one is Bankers Book Evidence Act 1959. Okay, it is specified that a copy of the entries in the Bankers Book is not to be obtained as proof under this act until it is first verified that the book was one of the bank's ordinary books at the time of entries and that the entries was written in the ordinary and the book is under the jurisdiction of the bank. Okay, next, the court or the judges also can request that any party be free to check any entries in the banker's book and take copies of them. Okay, second act is Anti-Money Laundering, Anti-Terrorism, Financing and Proceeds of Unlawful Activities Act 2001. Okay, it provides for a broader range of circumstances in which banks can reveal consumer information than the common legislation. Okay, the contracting party may in writing grant access to the data as would have been given to the Attorney General or his appointed officer by the responsible authority in order to comply with the requests of an international sector in form of increased collaboration in civil crimes. Okay, and the last act is Swiss Banking Act 134. It is claimed that the confidential identity of the borrower has been secured by the banker, by the use of a numbered bank account that the account holder is identified only to a small number of bank staff and the name of the client does not appear in records such as bank account statements. Thank you.
Welcome to the lecturer, Dr. Asparilla. Okay, next I will present about relevant law. Based on the assignment, relevant law was included, which is Personal Data Protection Act 2010, in section 141. Okay, where the act was told about the regulations processes of personal data on the commercial transaction. Also, the act also responsible of the privacy of the customer and also the customer data. Okay. Secondly, Central Bank of Malaysia Act 2009 under section 42(1). Okay, where the information is confidential between customer and bank. Okay, this is also about this secrecy of contract that was protected of both party personal information. Okay, third, Labuan Offshore Business Activity Tax 1990. Okay, where the offshore business could enjoy the tax treatment, and also the company must be registered under the Company Act, Offshore Company Act 1990, including of the foreign offshore. Okay, actually there are many law that was included in the offshore business, which is Banking Offshore Act, Insurance Offshore Act 1990, and also with the Security Industry Act also with Offshore Security Industry Act 1998. Okay, that's all from me. Thank you.
Moving on, Labuan Offshore Regulatory Framework such as Labuan Offshore offering credit facility and also receiving the deposit, where Labuan Offshore also provide offshore international banking business, Islamic banking business, and etc. Um, as in Labuan Offshore, all activities is secrets, which means that all the information are confidentially. Okay, there are a privacy consideration that including no public register of director and also the shareholders. Also, all the information will be kept in secrets about the ownerships, subject to the Secrecy Act provisions and cannot be revealed without any order from the High Court order, where any director of an offshore bank is prohibited from giving or disclosing any informations or any document related to the affair of or account of their customers, unless it is with an authorities letter.
Hai and selamat sejahtera to Prof. Madia Dr. Aspalela. Now I will continue to present about the case study. Okay, firstly, Labuan as a small island economy. Okay, Labuan is a very small island of this coast of Borneo in East Malaysia. Labuan also known as the world's of an offshore finance hubs, and Labuan also a part of Malaysia. This is because Labuan has many parallels to CIEs that are linked to economic institutions, which is recognized for their limited populations to be typically less than 1.5 million and lacks of technical skill. Even Labuan known as a small island of economy, but Labuan give the opportunities to Malaysia related to offshore. Next, Labuan is OFC or tax havens. Labuan is one of a small set of islands of the coast of Borneo and is considered a federal territory of Malaysia. OFC can distinguish from tax haven by hosting a variety of economic operations, whereas tax havens are focused on solely tax differentials with other countries. To solve this problem, Hamptons presented the typology of the OFC by classifying them into three categories, which is functionals, nationals, and compound categories. Okay, that's all for me. Thank you.
I will explain about the conclusion and recommendation. First of all, we know that Labuan Offshore Center is one of the important income and resources for government and banking. Not only that, in banking sector, the banking has a responsibility to protect a secret of their customer unless it's under the law. I will continue with the policy recommendation. First of all, further work is needed to facilitate the international cooperation. Next, we have to increase the public and political awareness of the problem of banking secrecy in offshore industry. This is important for people to know so that the activity can be stopped. So lastly, the bank and regulator must tighten the rules on issues related to bank secrecy and illegal activity. From that, the activity can be controlled and the government can see the illegal activity and catch the criminal. So that's all from me. Thank you.